That might be them. Just have them sit on the back rows. There's 7. That might be them. Just have them sit on the back rows. I'm gonna need a copy of this. We'll go ahead. Jefferson County Court at Law number 2 is now in session. The court is in session with its arraignment docket scheduled for 9 a.m. on today's date of February 7th, 2023. First case that we have on the arraignment docket is cause number 308772. The case is styled of State of Texas versus William Lance Squires. Mr. Squires, would you please come forward with your attorney? This is cause number 308772, case of style of State of Texas versus William Lance Squires. Mr. Squires, is that your full name?
Yes, sir.
Mr. Squires, how are you doing?
I'm doing good.
That's good. Mr. Squires, you're here represented by your attorney, Attorney Mike Reisinger. Attorney Reisinger, how are you doing?
I'm doing good, Lady Judge.
Mr. Squires, your case is set for an arraignment. And let me do this here, Mr. Reisinger. Would you please have these bond conditions for your client? Mr. Reisinger, you're charged with a DWI second.
Mr. Squires.
Excuse me, Mr. Squires, you're charged with a DWI second. And Mr. Squires, what your attorney, Mr. Reisinger, just handed you is titled Standard Bond Conditions in County Court at Law number 2. Do you see that document?
Yes, sir.
I will go over this document, which and it reads, following arrest and or accusation in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Absolutely.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body, and that is pursuant to the Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2. Do you understand that condition?
Yes, sir.
Now, condition number 3 does not apply, but condition number 4 does apply because you're charged with a DWI second, which is considered a subsequent offense under Section 49.04 through 49.06 of the Texas Penal Code. And condition number 4 reads as follows. A defendant who has been arrested or accused of any subsequent offense listed under Section 49.04 through 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator. And said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before the 10th day. And we're going to say after today instead of after arrest. Mrs. Squires, do you understand that condition?
Yes, sir.
Okay, now, Mr. Squires, if you violate any one of these conditions of this bond, your bond can be revoked, a warrant can be issued for your arrest, and you can be placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Now, you can provide the proof to your attorney, and your attorney will provide the proof of the interlock to the court.
I have no vehicle in my name, so.
Okay, well, any vehicle that you own or operate. So you cannot operate nobody else's vehicle if it does not have an interlock device on it.
Totally understand.
Okay. Now, Mr. Reisinger, did you send in a letter of representation?
I thought we did, Your Honor.
Could you check? You have one? Okay, so Mr. Reisinger, Mr. Squire's case is going to be reset to give you an opportunity to do discovery, negotiate with the district attorney's office. And then the next court date will be an announcement date. So you can sign for your reset. Once you get your reset, you'll be free to go, and you have a blessed day.
You too, Judge.
All right, thank you. And you have a blessed day as well, Mr. Squires.
Thank you, sir.
All right, please stand over there with your attorney. Once you go get the, call the rest of the document, you can have them sit up here.
Hello?
Mr. Allen, we are aware that you're there. We're in court. Please put your mic back on mute.
It should be, this is a whole case. Oh, it's a real, but if you'll contact, give us a couple days, contact, I should have an answer for it. Okay. Sounds good. Thank you, sir. Yes, sir.
Okay. Mr. Allen, you can take your mic off of mute. Court is in session in 3 cases. These cases are cases I was on the docket on yesterday.
Yes, sir.
First case is cause number 3277825, cause number 3277829, and cause number 331-893. All 3 cases are styled the state of Texas versus Nathaniel Deshaun Allen. We have Mr. Nathaniel Deshaun Allen, who is appearing via Zoom. Mr. Allen, how are you doing?
Right now I'm doing like literally like it's like an up and down thing. I'm at the moment to take care of my mother, and I'm also like dealing with jobs at the same time.
Okay. Now, Mr. Allen, the court will be praying that, everything is well with your mother. And the court also will be praying that you're able to take care of the matters that you need to take care of. Now, Mr. Allen, yesterday, your cases was, that door is locked. Yeah. On yesterday, your cases was called.
Say it again, sir.
Okay, on yesterday, your cases was set on our trial docket, and we were just informed today that you had called in and got a Zoom number, and you were unable to make an appearance via Zoom. Is that correct? Is that correct?
Yes, I was trying to make an appearance via Zoom because I couldn't make it this morning. Yesterday morning because I had my whole day sidetracked.
Okay. I mean, you could appear by Zoom. So we just confirming that you made an attempt to appear by Zoom, and you did talk to one of the court coordinators. Is that correct? Now the gentleman hold on a minute. Gentleman in the back on the cell phone, you need to put your cell phone up. You can't be having tell your cell phones off. Excuse me, Mr. Allen. Now, is that correct, Mr. Allen, that you attempted to make an appearance through Zoom yesterday?
Yes, sir.
Okay, I think you're probably having some difficulties on your on the Zoom. You're kind of breaking up a little bit. I think he froze. Yes, she's frozen now.
Hold on.
Yeah.
Does it work this time?
Yeah, it's better. That's better. Did you hear what I was saying?
Yes, I was trying to make a in call for via Zoom.
Okay, State, you have any motions?
No, you want to withdraw, a motion, bond forfeiture?
Yeah.
This time, we will do that, Judge.
Okay, the state is withdrawing the bond forfeiture. Give us a court date. April 24th. Okay, now, Mr. Allen, your cases will be reset to April 24th of 2023. Your attorney and your bondsman will be given notice of your reset date. Stay in contact with your attorney and your bondsman. You're free to go. Again, the court is praying that your mother is well and that you are able to take care of the matters that you need to take care of. And also, this will conclude your case, and you have a blessed day.
Thank you so much.
All right. Yeah. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. This morning, we have an arraignment docket, and what the arraignment docket is, it's an opportunity for the court to tell you what you've been charged with, what your options are, and what your rights are concerning your case. The case that you have here in County Court at Law number 2 is a misdemeanor case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your more serious type of offenses, whereas your misdemeanor cases are normally referred to as petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. For example, felony cases are divided into 5 categories. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If you are convicted of a state jail felony, your range of punishment, that is the punishment that you can get for the offense, is minimum of 6 months to a maximum of 2 years in the state jail and a fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment minimum 2 years to a maximum of 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is minimum 5 years in the state penitentiary to a maximum of 99 years to life. Now, if you're convicted and a fine up to $10,000. Now, if you're convicted of a capital murder case, your punishment will be life in the state penitentiary or death by lethal injection. Now, the case that you have here is not a felony case. So the case that you have here is a misdemeanor case. Misdemeanors are divided into 3 categories. We have our Class A, Class B, and a Class C misdemeanor. Class C misdemeanors are normally those cases that you see in the JP court or the city court. And with a Class C misdemeanor, you cannot be given any jail time. You only can be given a fine. For example, a good example of a Class C misdemeanor is a speeding ticket or you're not wearing your seatbelt. Now, however, when those cases are appealed from the JP court or the municipal court up to this court, the range of punishment is the same. Now, if you are given a fine and if you fail to pay your fine, then a capious pro fine can be issued, which means that you could be placed in jail to sit out the fine and court costs that you failed to pay. Now, the other misdemeanor is a Class B misdemeanor. With a Class B misdemeanor, the range of punishment is 0 days to 180 days, which is 6 months in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. If you are convicted of a Class A misdemeanor, the highest misdemeanor, the range of punishment is 0 days to 365 days, which is a year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that you have, we handed out to you on the clipboard, And I'll go over it with you. First of all, on the document that is titled Judge's Explanation of Rights to Defendants Without Attorney, as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may give up your right to have an attorney and represent you, and you can represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset so that you can have enough time to hire your attorney. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to waive your right to have an attorney and represent yourself, then you cannot speak to the prosecutor. Now, the prosecutor is the gentleman that's sitting at that table. The prosecutor is an assistant district attorney. He works for the district attorney's office. Now, if you want to represent yourself and if you want to speak to him, you cannot speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. What a waiver of your right is, you're waiving your right to have you are giving up your right to have an attorney, and you will be representing yourself. Now, be aware that there are dangers to self-representation. If you want to represent yourself, there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and request an attorney from the court. At the bottom of that, at the bottom of that document in bold letters, it says defendant's choice. Mark initials next to only one choice. Now, if your choice is I want to reset my case means that you want to be given another court date. And now if you want to reset your case to hire your own attorney, then you'll put your initials on the first line to the left. If you have already hired an attorney to represent you, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is I want to apply for a court-appointed attorney, then you'll put your initials on the third line to the left. If you have already been appointed a court-appointed attorney in your case to represent you, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right or give up my right to an attorney and represent myself, then you will put your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you would date it today's date, February 7th of 2023. Now, the next document is for those individuals who will be waiving their right to an attorney, which means are giving up their right to attorney and representing themselves. And that document states waiver of counsel for purposes of entering a guilty plea or proceeding to trial. And it reads, I have been advised of the nature and the charges against me. If anyone who has a phone, please turn your phones off. Okay. And the document reads, where is that? Turn your phones off. Okay. Now, where it says waiver of counsel for purposes of entering a guilty plea or proceeding to trial, it states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 7th day of February 2023 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed to represent me free of charge. Understanding my right to have counsel appointed to me free of charge, I am, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. If that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, February 7th of 2023. Now, ladies and gentlemen, you also have other rights. One of the other rights that you have is the right to have a jury trial. The area that you're sitting in, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your jury if you choose to have a jury trial, and they will decide whether or not you're guilty or not guilty after listening to all the evidence. Now, you also have a right to waive your right to have a jury trial, which means you have a right to give up your right to have a jury trial. And by doing so, you will not be having a jury trial. However, your case will come before the court or the judge in one of 3 ways. One way it would come before the judge is by way of a bench trial. And what a bench trial is, if you desire to have a trial without a jury, it is a trial by judge only. So the judge will listen to the evidence. The judge will decide after listening to all of the evidence whether or not you're guilty or not guilty. The other way that your case will come before the judge is by way of a plea bargain. It can come before the judge by way of an unagreed plea bargain. Unagreed means that you have not been able to reach an agreement. And then what I'm talking about, you have not been able to reach an agreement with the district attorney's office to settle your case. And if that is the case, then your case will come before the court or before the judge, and the judge will decide what punishment you will be given. And the reason why the judge will decide, because you would have already pled guilty or no contest. In essence, there are 3 ways you can plead. You can plead not guilty. If you plead not guilty, you're saying that you did not commit the offense that you've been charged with. You can plead guilty, and if you plead guilty, you're saying that you committed the offense that you've been charged with. Or you can plead no contest, and if you plead no contest, you're telling the court that you will not be fighting or you will not be contesting the charges. So if you enter a plea of guilty or no contest and you want an unagreed plea, then the judge will decide what your punishment will be. Now, the other way that your case can come before the judge is by way of an agreed plea bargain. That is, you and the state have reached an agreement concerning your case. And now the court does not have to follow that agreement. If the court does not follow your agreement, you have the right to withdraw your plea or to take back your plea. So for example, let's say you and the state has reached an agreement and the agreement is for you to serve 1 day in jail. And it comes before the court and the court said, well, I'm not going to follow that agreement. Then you can tell the judge, well, judge, I take my plea back, okay? You have a right to withdraw your plea if the judge does not follow the plea bargain agreement. Now, if the judge follows the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case, in essence, to have a higher court to review your case to see whether or not you've been wrongfully convicted or this court committed an error by convicting you, then you have to get the court's or the judge permission to appeal your case. And if your case is appealed, it will go upstairs to the Ninth Court of Appeals. They will review your case and they will determine whether to grant or deny your appeal. If they grant your appeal, they could simply find you not guilty, or they could send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, you could appeal it to a higher court than the Ninth Court of Appeals. You could appeal it to the highest criminal court in the state of Texas, and that is the Texas Court of Criminal Appeals located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. What that means is you'll be filing this document on your own, asking them to review your case. If they review your case, they can either grant or deny the petition. If they grant the petition, they can just simply find you not guilty, or they can send the case back down to this court to order this court to give you a whole new trial. Or if they deny the petition, then at that point, your conviction will stand. Now, as a defendant, you also have a right to have a trial. Well, you also have a right to have witnesses to come to court. When that young man is sitting in that area, we call that the witness stand. And what witnesses do, they can testify for you or against you. If you're representing yourself or you have an attorney, they can ask you, or your attorney can ask them questions. We call it either direct examination or cross-examination. You also have a right to waive or give up your right to call witnesses on your behalf. And by doing so, that does not mean that the state will not be calling witnesses. They will be calling witnesses to prove their case. Also, You also have a Fifth Amendment right against self-incrimination. That is, you have a right not to testify in your case. The state of Texas government cannot force you to testify against yourself in your case. Now, you can waive or give up that Fifth Amendment right. And by doing so, if you waive it or give it up, then you will be testifying in your case. So a lot of times when I talk about the Fifth Amendment, I mentioned that a lot of people refer to it as taking the fifth. You know, if you watch television, they always say, I take the fifth, I'm not testifying. Now, you also have a right to have discovery. And what discovery is, you have a right to see the evidence that the state has against you. You have a right to see documents. You have a right to see the videos, listen to tapes, photographs, instruments. You have a right to have access to those items or to the evidence. Now, if you're represented by an attorney, your attorney will have access to the evidence. So if you're representing yourself, then you will be allowed to have access to the evidence. Now, you also have a right to give up your right to have discovery. In essence, you want to have access to the evidence that the state has against you. You have a right to waive your right to have discovery. Now, everybody that's here you've been here, you've been arrested, and so you're out on bond. You're either out on a cash bond. Cash bond means you paid up the full amount to get out, or you're out on a surety bonds, means that you pay a bondsman a percentage of what the total bond was, usually like 10% of that bond to get out. Or you are out on a PR bond, personal recognizance bond, meaning that you did not have to pay any money to get out. You were let out on your own personal recognizance and you promised to appear here in court for your court days. Now, every day that you spent in jail, you will be given credit for that time. So, for example, if you're in the state has worked out an agreement, let's say you spent 5 days in jail, you're in the state has worked out an agreement to settle your case, a plea bargain, and the agreement is that you will serve 5 days in jail. That simply means you will not have to serve any more time in jail. Why? Because you've already served 5 days in jail, and you will be given credit for the time that you've already served. Now, if they are for 7 days in jail, you serve 5 days in jail, then that means that you would have to serve 2 more days in jail. Now, every day that you spent in jail can be used as credit toward your fine and court costs. You get credit at $100 per day. Every day that you spent in jail, $100 will go toward your fine and court costs. So, for example, you're in the state has reached a plea bargain agreement for $500 fine and court costs. You've already been in jail 5 days. That's $500. You would not have to pay the $500 because the fine and court costs will be taxed and retired. Now, if they're offering $700 fine and court costs, you spent 5 days in jail, that means you have to pay $200. Now, you will be required to pay the $200 on the day that your case is disposed of. If you cannot pay it, then the court can put you on what is called a payment plan, where you could pay off your fine and court costs over monthly installments. Now, let's say even if the court does that, because you do not have any finances, you will still be unable to pay the fine and court costs. So the court can convert your fine and court costs to community service, and you will be given $12.50 for every hour of community service that you do at a nonprofit organization. Now, if you work 8 hours of community service in one day, that's $100. That can go toward your fine and court costs. Okay. Now, Jefferson County has a program that is called pretrial diversion. With pretrial diversion, if you haven't been in trouble before, this is your first time being in trouble, they have a program where they will dismiss your case, put you in the program. Once you're in the program, and if you complete the program, you can get the case expunged from your record. Expunged means erased, deleted, or wiped off from your criminal record. Now, in order to get into the program, you have to have an attorney. It has to be your first case. It cannot be a case involving unlawfully carrying a weapon or resisting arrest. If you are a veteran of any one of the branches of the United States military, Jefferson County has a program that is called Veterans Court. It's for veterans only. With that program, they will you get into the program, and the same thing is part of the pretrial diversion program. So the same thing essentially will happen. If you're interested in the program, let the court personnel know, and we'll be able to get you the paperwork that you need to get into the programs that I just mentioned. Now, This court has a program as well that I started within 100 days of taking office in March of 2017. That program is called the CSI program. CSI stands for Community Safety Initiative. With that program, the program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, let them go to school, for us to go to church as well. And the way the program works is we have partnerships with agencies in the community. For example, we have a partnership with Spindletop. We have some personnel here from Spindletop today. And what Spindletop is, Spindletop Center is our local mental health center. They will do private interviews. They can develop an assessment plan and develop a treatment plan, either outpatient or inpatient, to treat your mental health needs. Now, when I say mental health needs, you do not have to be insane or incompetent. You may suffer from anxiety, depression, bipolar, schizophrenia, or a whole host of other mental illnesses, and they will be able to assist you and address those issues. Now, if you have issues with drugs or alcohol, Spindletop has a program that is called ATAR, and our local Drug and Alcohol Council has a program that is called OZAR. Both of those programs are designed to make Jefferson County a safer place, and basically they can do screenings, they can do assessments, and they can do referrals to the either outpatient or inpatient treatment to address your drug or alcohol needs. If you're unemployed, do not have a job, then we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, shipping industry, and the chemical industry. And if you are interested in any one of those areas, once you're trained, they will assist you at getting a job in the area that you're trained in. If you have not graduated from high school and you would like to get your GED, a graduate equivalency diploma, CICE has a GED program. And now all of the programs that I have just mentioned to you, all of those programs are free, does not cost you anything. Only thing you have to do is have a desire to be in the program. And as I mentioned earlier, those programs are designed to address the issue of recidivism, basically, which means that people commit crimes over and over. And so how do we address it? We address it through our community safety initiative, with our job training program, with our mental health program, with our drug and alcohol program, and with our education or our GED program. Now, I tell people this all the time: when you come to County Court at Law Number 2, we don't have court as usual, we have unusual court. And it's not because we're different, it's because we're trying to make a difference in the lives of the individuals that comes before this court, and we're trying to make a difference in Jefferson County, the county or the community in which we live. Also, in County Court at Law Number 2, we do not just arrest the problem, we address the problem. And we do that by not just giving time, but by taking our time. And we believe by taking our time, we can produce productive people. And if we produce productive people would not commit crimes. Why? Because they have too much to lose. And so if you're interested in any one of these programs, just let us know. We have paperwork that can be given to you. Now, at this time, as I mentioned to you earlier, we have personnel from our Spindletop Center, and we're going to have Spindletop folks from our Spindletop Center that's going to come before you and tell you a little bit about their program. Okay, Mr. Hinton, Chris.
Morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state and commissioned with the sheriff's department here. This is my co-workers here, Chris and Danny. Both of these ladies are qualified mental health professionals. The reason we are all here this morning is because the judge has graciously invited us in his courtroom because he cares about every single person coming before the bench. The judge has found is those who appear with legal issues commonly have mental health, substance use disorders, or sometimes just a lack of community resources to help you in your particular need.
Yeah, I think that, we talked with them, but this is also something that's where, sometimes this where they things that we all deal with in our normal day-to-day lives. Now, whenever you're talking about community resources, there's a lot of things in our community that are great and they're well funded, but they're not necessarily well advertised. Getting set up, it's a little bit more difficult. Either we have to internet or transportation, or whenever you guys are in a situation like this where you're having to work, you want to juggle. Add anything else, even if it's something to help, can you just make it that much more difficult to manage the rest? That's not how we step in. If we need help with anything like that, we're able to do so. Where the one who set those up. We're gonna hand out a paper in just a second. I don't know if they already got it to you or not. This functions as a baseline typical consent form. That means that your information on here is protected under state law. It will not be shared outside of your permission. The only thing this allows them to do is contact the board to provide that information. Outside of that, it also gives you the option to speak in the back. You can do that for other resource connections, or if you know that you need to, or maybe like I said, it's not a situation. Want to find ourselves in, if the admission stays a little bit heightened, or you need to step through that, just have a moment to breathe. That's what we do.
So this may be your first time to be here. It may be a time to be here. There's still hope. This program absolutely works. But we're gonna need one thing from y'all on this document that we're gonna pass out to y'all in just a little bit here. We're gonna need you to share that need with us. We have no idea where you are in your walk in life. If you will share that need, we can get you connected with resources that fit your particular situation, but we don't know what that is if you don't find the necessary information so we can follow up with you. And that's what we'll do.
Now, also about the resources, as the judge mentioned, several of them in the community that are grant funded or study fees. Anything we set you up with will also be that way. If you need to come to us to talk about stress or anxiety, it will not cost you anything. If you need physical health care, job training, if you're trying to get on state benefits, if you're trying to get set up with some financial assistance, the resources we get you connected to will either be a sliding fee scale where it's a minimal cost and will help you make sure that you get on the lower end of it, or it won't cost you anything, because we're not trying to add extra financial stress on the whole mix. Outside of that, he's going to hand you this pamphlet. It is an excellent resource in itself because it has, so we usually call on, or we usually try and connect on Wednesdays and Fridays. On that pamphlet, it does have our office number. So if you need to talk to me beforehand, if you realize that, you know, there's something you need help with and you want immediately, you can call them and they will get you connected to me. Or Danny, actually. So
We'll hand this out to you just shortly to make sure everyone has what we need for today.
there is something else on that pamphlet. It is a 1-800 number. It is a crisis hotline. Now, the thing about that is we understand that people come to court in Jefferson County who don't necessarily live in Jefferson County. That doesn't negate the fact that we can still work with you. That 1-800 number on here is almost completely statewide. So 9 out of 10 times you call it if you are in a moment of crisis, someone who knows a moment of crisis, or even just if you work downside the road or out of your general area you don't know who to get in contact with, they can help. So it's a good one just to keep with you, just have in the car, or maybe give to friends or family if you know them. So he's gonna hand that out, and I'm gonna hand this out. You should have pins with your clipboard, and if you need anything, please let me know. We're here to answer any questions.
We'll just wait until everything goes into recess. When the judge goes into recess, we'll be visiting with each of them. Thank you.
Okay. Okay, ladies and gentlemen, the paperwork that you have on the clipboard, we're gonna pick that paperwork up from you, then we're gonna put you in one of 3 categories. Either you want to hire an attorney, you want to see if you qualify for a court-appointed attorney, or you want to waive your right for an attorney and represent yourself. Now, if you need any assistance or any help with the clipboard, with the information that's on the clipboard, we have court personnel who's here that's ready to help, okay? And I think he'll need assistance, and we may have to get Jennifer. I don't know, but you can check to find out whether or not we need Jennifer. And so at this time, the court will be in recess to give you an opportunity to finish filling the paperwork out and give our court personnel an opportunity to pick up that paperwork from you. And this is going to take a few minutes, okay?